Today on the webinar, we're talking about estate planning, wills and trusts. And we have two experts from the Acuity team who will be giving a presentation for 20 minutes, and then there'll be 10 minutes for Q&A. And we'll also take some questions halfway through the presentation. So I'll hand over to Phil, who'll be giving the presentation. And as I say, put your questions in the Q&A and we'll cover off as many as possible.
Following on from our investment and financial planning webinar from Tuesday, we'll now look at this today in more detail, and specifically wills and trusts and the key steps to protect your assets. So clearly, in a time of a global pandemic, it is vitally important to ensure that life cover and estate planning are both fit for purpose and up to date. And due to the lockdown, we're finding that people now have the time to really address these important issues. So the agenda for today will be as follows. Why should you make a will, or perhaps more importantly, the implications of not having one, the roles within the will and who you could select and why, the role of probate and the process of pulling the estate together and officially registering it, some important points to consider regarding will construction, the risks that the estate faces, and these risks are for no planning or for very basic planning, and then the solutions to these and how we mitigate these risks. And at the end, I'll look at lasting power of attorney and why these are so important and who should consider establishing them. So I'll now pass over to my colleague Adrian, who will talk you through the next few slides.
Thank you, Phil, and good afternoon, everyone. I hope you're well. So first, let's consider why you would make a will. So for those that die without a will in place, they will die in what is called intestate. So there are various rules around this, but the implications of not having a will for a married couple with children would be the surviving spouse may not inherit the whole estate. Unmarried couples, the implications would be the surviving partner gets nothing as the entire estate passes to any children, and if there were no children, then it would be split between siblings and parents if possible. A married couple that have separated, the implications would be that the surviving spouse would be entitled to claim part or all the estate. So making a will is the only way to ensure that the estate is distributed to the people that you would like to benefit from it. So moving on to the next slide, you can see here that writing a will require you to make some decisions with regards to some key roles within that structure. And this would involve guardians for the care of children, trustees who look after and manage assets, the executors, and of course the beneficiaries who will ultimately receive the estates. I've mentioned the executors. Okay, so the executors are required to pull everything together and make the submission for probate, as well as calculate assets for inheritance tax purposes. So the bottom line here is that the job is time consuming, it's difficult, and the executors are legally liable. So when selecting an executor, consideration should be given to individuals, but also professionals such as solicitors, accountants, and trust corporations. Thank you very much. I'm just going to pass back to Phil, who's going to cover off probate.
Thank you, Adrian. So let's talk about probate. This is essentially the process for proving a will. The executor, as Adrian has mentioned, pulls together the estate information and submits it for approval. So this is especially important for unmarried individuals or second death cases within a marriage, and I'll mention why shortly. The executor must provide the probate registry with the most recent will, and this is the original document, and this needs to be sent off, and some people are sometimes unaware of that requirement. So this evaluation of the assets of the deceased is passed from probate to HMRC. As mentioned earlier, this becomes more important for unmarried or second death cases, as an inheritance tax liability could be due. For first death within marriages, there is no inheritance tax payable. So we would therefore tend to recommend that a professional executor will be considered for unmarried or second death probate cases, and the consequences of miscalculations could be very severe. So once completed, the executor obtains a document called the grant of probate and can then do the job of actually distributing the estate to the chosen beneficiaries. If there is no executor, but a valid will, the beneficiaries then have to apply for something called the letters of administration, and then they have the authorization to complete probate. All estates over £5,000 are required to go through probate or letters of administration, whether there is a will or not. It's also worth noting that some financial institutions will release funds in excess of 5,000 without the grant of probate or letters of administration, but that's down to their individual policy and is not the law. So moving on to the next slide, which is the important points to consider. It's very important for a will to be valid, and for a will to be valid, it needs to be signed and witnessed. And this understandably caused some issues of lockdown. There were stories of legal teams meeting clients in car parks and signing documents on the bonnets of cars. But actually, it has become fairly straightforward, with neighbours witnessing signatures through windows and leaving documents on doorsteps to be picked up. And this is wholly legally binding. It's also really important to consider testator capacity. Is the individual mentally capable to make or amend a will? They will need to demonstrate sound mind and understand the nature of the act. They need to understand that he or she is making a will and its effect. They will also need to demonstrate a sound memory and understand the extent of his or her property. You may well know that wills can be contested if there is specifically a question in this area. And we always suggest that if this is a potential issue, the client seek a GP letter to confirm testator capacity. Exclusions can also be included, and these individuals will be either children or more usually an ex-spouse. This needs to be robustly worded. You may well have seen a case a few years ago when a lady died and left her estate to a local cat sanctuary, and she excluded her daughter. And her daughter pursued this case in court, and a few years later, the case was overturned and the daughter actually received the full estate. And this was purely because the wording was not comprehensive enough in the will. So we need to really emphasise that point. And looking at the next slide, we look at the risks of no will or very basic planning. And this can be split into two quite distinct sections for a married couple. The event of first death and then the event of second death. So the risks on first death, when there's no planning or very basic planning in place, will be around care costs. So following the first death, should the surviving spouse need care, then the whole estate, including the family home, will be assessed to pay for the cost of that care. And some of you may have experience of this with friends or extended family. I personally do, and I found it heartbreaking that a family home was lost in this way. Marriage after death, sometimes referred to as MAD. On the first death, all the assets are then solely owned by the surviving spouse. So what if the surviving spouse remarries? The inherited estate could be lost to the new spouse, disinheriting the children. So imagine a scenario, a widow finds a new friendship or romance, maybe in a care home with another resident. They decide to impulsively get married. The widow's two sons initially think this is really sweet and they're glad that mum or dad is no longer lonely. However, they then find out that their new stepmum or dad has 4 other children and their future inheritance is now split 6 ways rather than 2. Creditors or bankruptcy. If the surviving spouse were to be subject to a creditor claim or bankruptcy claim, then the inherited estate is fully at risk. And if we then look at the next slide, we look at the risks on second death. So inheritance tax. Inheritance tax, I've heard described as a voluntary tax, only payable by those without tax planning, or actually more accurately, payable by their families. So this inheritance tax liability would be payable on any amount in excess of the couple's nil rate band. And I'll spend some time a little bit later talking about the nil rate band as it's an important issue. Divorce. So if the children or chosen beneficiaries are subject to divorce proceedings, then half of what was intended for them to receive is at risk to future divorce settlements. Creditors or bankruptcy, again, similarly, if any of the beneficiaries are subject to creditor claims or bankruptcy claims, then the inherited estate is fully at risk. Their own future care costs. If the inheritance has been passed to the chosen beneficiaries, these assets could later be assessed for their own future care costs. And lastly, generational inheritance tax liability. So on second death, the remaining estate is likely to be directed by the will to the beneficiaries. This then adds to the beneficiaries' estates and could impact their own inheritance tax. So think of this, for larger estates, this could run through many generations, building up a truly significant tax liability. So as you can see, the common theme running through these risks is the risk associated with absolute ownership. If there is one sentence I'd like you to take from today, it's that absolute ownership is the enemy of successful estate planning. So let's look at how these risks can be mitigated. And the answer to this question is by the use of trusts. So there are several different trusts available, but we will just discuss the two most relevant to estate planning. And those two are discretionary trusts and life interest trusts. So looking at discretionary trusts, the main benefit of a discretionary trust is its flexibility. So within a discretionary trust, there are potential beneficiaries, and these follow from the will. No beneficiary has entitlement to the capital or the income of the trust, as it's down to the trustee's full discretion as to who, how, and when any beneficiary could benefit from either income or capital. And this is in line, obviously, with the testator's wishes. Hence, it's really important who is then appointed as the trustee. If we then look at the next slide, which looks at life interest trusts, income belongs to the interest in possession beneficiary or life tenant, and income can also mean the right to live or a life interest in the property. Essentially, both structures work in a very similar way, but there is quite a key difference. Assets passed to the discretionary trust above the nil rate band could be subject to a tax charge. The nil rate band has historically been £325,000 per person for some time, but this has recently changed to the residential nil rate band, and it's now become £500,000 per person, with the additional £175,000 allowable if the residential property is passed to a direct descendant. So unlike a discretionary trust, the assets passed to the interest in possession trust above the nil rate band do not trigger this potential charge. And this is an important point in terms of the planning. So the benefits of trust planning, let's look at these, at the risks mentioned earlier, and then describe how the trust planning can actually mitigate those risks. So care home costs. So holding the assets in the trust ensures that they do not add to the beneficiary's own estate, and so they cannot be assessed for their care home costs in the future, creditors or bankruptcy. Similarly, if any of your beneficiaries are subject to creditor claims, bankruptcy claims, then their inheritance would not be exposed to these claims. Further, or generational inheritance tax. Holding the assets in the trust ensures that they do not add to the beneficiary's estates and impact on their own inheritance tax. Marriage after death. Placing half of the family home and other assets to a trust on first death ensures that, should the surviving spouse remarry in the future, those assets cannot be taken into the second marriage, and it removes the threat of your own children being disinherited. The survivor is still able to use the assets in the trust. Divorce. So placing the assets into trust ensures that if your children or chosen beneficiaries are subject to divorce proceedings in the future, then what you intended them to receive is protected from any divorce settlements. So let's look at that in terms of a picture. I tend to find that illustrations really highlight the planning quite well. And this would be one of our fairly standard solutions for a couple with an estate value above the nil rate band. So the property ownership here has been changed from jointly owned to tenants in common, and this is important. Again, the reasoning here is driven by the absolute ownership issue that we mentioned earlier. If the property is set up jointly, then on the death of, say, Mr., Mrs. would absolutely own the entire property. With the structure highlighted on screen, if Mr. was to die, then his 50% share of the property would pass to the family trust. Mrs. would own 50% of the property and would be trustee and beneficiary on the other 50%. Now, the important bit here is for care home fee calculation purposes, the property is fully protected because Mrs. only owns half a house, and half a house has a value of 0. So the home is therefore protected from the grasp of the care home fee potential down the road. So regarding the full distribution of assets in this example, Mr.'s 50% property share and any other assets he owns up to the nil rate band pass to the family trust, which is a discretionary trust, and any assets owned above the nil rate band will pass to the interest in possession trust. The assets in the trust are now protected against all the risks that we mentioned earlier. It's also worth noting at this point that if any business assets are owned, in addition to the personal assets we've discussed, then we would include one or a series of business trusts that work in exactly the same way as those just mentioned, but will be specifically used to capture business assets. And I'll now pass back to Adrian to discuss trustees.
Thank you, Phil. Thank you very much. So let's just consider what the role of a trustee is. So the role of the trustee, quite simply, is just to look after and manage trust property on behalf of the beneficiaries. Now, trustees can be changed over the time that the trust is alive, and this won't impact on the trust, but there should always be at least one trustee. Now, following on from what I've just said there, although the trust can have one trustee, ideally, there would always be at least another trustee in reserve to act in the future. Also, if there is a child named as a trustee, then there should also be a substitute trustee to act on a temporary basis on their behalf if they are under 18. Now, just a quick note here on beneficiaries, or when stating beneficiaries, it's usually best to use a class of beneficiary which involves stating, for example, the grandchildren of Mr. X, rather than stating the individual grandchildren, as there may be further grandchildren born later on which would not be included in the will. And we would always recommend that there is more than one beneficiary, just in case anything were to happen to that beneficiary, then there would always be another beneficiary there, and that would avoid the estate being lost. Back on the subject of trustees, so who would you appoint as a trustee? Well, in nearly all cases, we see a spouse as the first trustee. You could, of course, use a tax corporation, but this would come with its own implications that you need to be aware of. We generally do not consider children or other family members or friends as initial trustees due to the nature of the role, but we could consider them trustees later down the line as replacement trustees, if that was what you wanted. Okay, thank you very much. I'll pass back to Phil now, who will cover off lasting power of attorney.
So yes, I'd like to just finish now by just discussing LPAs, or lasting powers of attorney. If you were to suffer an accident and be confined to a bed or hospital, or contract an illness, or have a more serious accident that permanently incapacitates you, or you become mentally incapacitated as a result of old age, then without an LPA in place, the only way your financial affairs can be managed is by an application by a relative or someone close to you being made to the court. Now, many people still believe by just being married, they'll automatically be granted this responsibility, and this is not the case. This process costs a considerable amount of money and can take anything between 12 weeks and 10 months, by which time finances can be seriously damaged. And even worse, a judge will make the final decision as to who is actually appointed for the role. It is currently estimated that about 55,000 people are registered with the Court of Protection who are deemed mentally incapable to act on their own behalf, and their affairs are placed under the jurisdiction of the court. So this would mean that those seeking to care for you, such as your family, would have the added stress of having to deal with officials every time a decision needed to be made. So they would also have no official say in any medical treatment for you, even when they knew what your wishes would have been. So the way to avoid this is to establish lasting powers of attorney. And there are two types, as you'll see on the screen. There's health and welfare, and there's property and finance. And it is crucial, absolutely crucial, to establish these whilst you still have capacity. So we always suggest that our clients consider establishing lasting powers of attorneys as a matter of our process, but they are particularly important for those slightly older or vulnerable clients who are concerned that they are closer to this kind of issue. So I hope that's been helpful. What the key messages from the presentation to be: review any current planning. So we provide a free service to review any wills or trusts in place to check that they are fit for purpose. Establish planning if none is in place. Again, we're very well placed to help with that. And lastly, just take the message that absolute ownership is the enemy of successful estate planning. So I believe that's all from Adrian and myself, and I'll pass back to Rosie.
Okay, so thank you for joining today, everybody. Our next webinar is on Tuesday. Every Tuesday, we have an update on the broad government support measures that are available to SMEs and the self-employed. So do register and join that one. If you haven't joined a 12 o'clock Tuesday session before, do check out the YouTube channel and the previous recordings, because within that hour, we only have time to do the latest updates from that week. So do access the previous recordings before you join. And thank you very much for joining, and we look forward to welcoming you again soon.